Hi everyone, welcome back to my channel. For today's video, we're going to be looking at an example of a libel case that has been successfully appealed and ordered to be retried in the UK. Before I get into today's video, I do want to remind everyone that I do have a video specifically on the appeals process in the UK, which I released back in late July or early August, basically right after the trial ended. And the reason I'm bringing it up again is because I keep receiving lots of questions about the appeal, and a lot of these questions have actually already been answered in that video. So it's always linked down below in the description box. So please do watch it. It's only 7 minutes long and it is quite comprehensive. Alright, so the structure of this video will be as follows. I'll start off with a very quick rundown of the facts of this case, because it is important that we know what we're talking about rather than just jumping straight into the Court of Appeal and the Supreme Court's reasoning. And then we'll only be looking into the relevant aspects of this appeal. So anything that doesn't really apply to Johnny's case, because I do understand that the interest here is primarily Johnny and the outcome of his appeal. So only parallels will be discussed, or only analysis that applies to Johnny will be discussed. Everything else will not be discussed, and if you are interested in reading more, the links to all the judgments will be in the description box as well. So that's the original judgment made by the trial judge, the Court of Appeals judgment, and then the Supreme Court's judgment. Alright, so the claimant in this case is Mr. Serafin, or Serafin. I did try looking up how to pronounce his name. I came across a very familiar pronunciation to me in Italian, which is Serafin, but it may be wrong because he's Polish. So I will be referring to him as the claimant. So the claimant is a Polish businessman who immigrated from Poland a long time ago. So he's been based in the United Kingdom for most of his life, and he set himself up as a businessman here, primarily working in the building industry, and eventually, after attaining a level of success, he started to branch out of the building industry. In October 2015, an article that was published in a Polish magazine defamed the claimant. Specifically, they called him a liar, a manipulator, a thief, a greedy businessman, a cheat, a womanizer. The list goes on. The claimant decided to self-represent during the trial, which unfortunately did not work out in his favor. It was pointed out by both the Court of Appeal, so the first port of call for appeals above the High Court, and the final Court of Appeal in England, the Supreme Court, that the trial judge, who was not Mr. Justice Nicol, by the way, I did want to clarify that, was incredibly rude and hostile, and overall behaved in a manner that was entirely inappropriate, entirely biased, and displayed quite a level of animosity directed at the claimant. Now, in this case, the defendants relied primarily on the defense of public interest, which is found in Section 4 of the Defamation Act 2013. It's essentially a defense claiming that the publication of the article in question was in the public interest. The defendants also relied upon the defense of substantial truth, which is the one that is directly applicable to Johnny's case, and to some extent, honest opinion, found in Section 3 of the Defamation Act, was also referred to. The judge found for the defendants and ruled in their favor, so he dismissed the libel claim. The main gist of the judgment was that all of the evidence provided by the claimant, including his witnesses, was deemed to be unreliable or lacked credibility in the eyes of the trial judge, whereas all of the evidence provided by the defendants was relied upon and described as credible. This was done despite the fact that the defendants did not provide any substantial evidence to back up their claims. So essentially, the trial judge relied on their testimony. If that rings a bell, then you'll understand why now I've decided to talk about this case. The claimant appealed on 5 grounds. The first one being that the defense of public interest should have failed, and we will not be discussing this defense in any detail, as I said, because it doesn't apply to Johnny's case. However, I will make references to a few of the Court of Appeals remarks in relation to the journalistic standards that are expected of editors and publishers and journalists. Now, I will only be making a brief reference because unfortunately the Supreme Court, which is the court above the Court of Appeal, found that there was an error of law in the way that the Court of Appeal applied the law to the facts of this case. So they made a mistake that was rectified by the Supreme Court. It is beyond the scope of this video. But again, whatever I'm going to tell you about journalistic integrity, unfortunately ended up being effectively overturned by the Supreme Court. The second ground of appeal is that the judge was wrong to have found that the defense of substantial truth was satisfied. Ground 3 was in relation to a reversal of the burden of proof. So the claimant's alleging that the judge effectively reversed the burden of proof because he expected the claimant to prove his innocence rather than the defendants to prove the truth of their allegations. Now, if you remember from my previous videos on this topic, the burden of proof of proving truth, so relying on the defense of truth, falls onto the defendants. It is on the defendants to prove the truth of their allegations, not the claimant to prove their innocence. Grounds 4 and 5 don't apply at all to Johnny's case, so I won't really be talking about them. I will quickly say, in anticipation of people saying the judge was unfair in his decision against Johnny, this ground was not about the decision per se. It was about the judge's conduct during the trial. As I said, he was highly inappropriate. Mr. Justice Nicol, as much as a lot of people may disagree with his judgment, including myself, conducted himself in a manner that was appropriate of a judge. I went through thousands of pages of transcripts, all of the pages, as you know, to make my videos, and I didn't come across a single instance of him being rude or dismissive or behaving in any way that was unbecoming of a judge. All right, so what I was talking about in relation to the Court of Appeals remarks on journalistic integrity. So basically, the Court of Appeals said that journalists are expected to give the other side a chance to respond before publishing the article. Now, it is important to point out that this is strictly in reference to the defense of public interest. So subsection 1b states that the defendants must have had a reasonable belief that publication was in the public interest. And while this doesn't apply directly to Johnny's case because NGN relied on the defense of truth, I did find it interesting that this concept of reaching out to the other side and getting their side of the story before publication was found to be quite important by the Court of Appeal. And then here later on, as you can see in this paragraph, the Supreme Court reaffirmed this general stance. A failure to invite comment from the claimant prior to publication will no doubt always at least be the subject of consideration and may contribute to, or perhaps even form the basis of, a conclusion that the defendant did not have a reasonable belief. But this is where they differ from the Court of Appeal. They go on to state that to describe this attempt to reach out to the claimant as a requirement is too strong. Now, Johnny's team did make reference to this in their arguments during the trial, that NGN failed to contact Johnny or anyone from Johnny's side at any point before publication. And this is why I decided to talk about this point. So when I read the Court of Appeals judgment before I got on to the Supreme Court's judgment, I did feel that, again, despite the fact that this defense was not relied upon by NGN, the argument of NGN's failure to reach out to Johnny to verify these incredibly serious allegations being made against him could be seen as a very important grounds to appeal the case. But unfortunately, again, as we see here, the Supreme Court noted that that was too strong of a position and that while it can form a basis of an argument, it cannot be described as an absolute requirement. So NGN or any other journalists for that matter don't have an absolute requirement to reach out to the claimant and verify their allegations before publication. Now, in relation to the second and third grounds of appeal, the Supreme Court found no issues with the Court of Appeal's reasoning and decided not to revisit that topic. Now, they did this also because they essentially ended up ordering a retrial. So it was kind of futile to refer to the Court of Appeal's judgment because at the end of the day, the entire case is going to be retried from scratch. But the fact that they had no qualms or no issues with the Court of Appeal's reasonings and findings is, again, encouraging. Specifically, in paragraph 50 of the Supreme Court's decision, of course, it is rare for the Court of Appeal not just to set aside, but even to reverse a finding of fact made by a trial judge. But the court may have been justified in doing so. There is no need for us to look into it. Now, we're going to look into the Court of Appeal's actual reasoning with regards to why the defense of truth failed. And it is quite encouraging because of the parallels that exist between this case and Johnny's case. I want to start off with paragraph 86. That paragraph basically says that courts of appeal rarely interfere with findings of fact that have been made by the trial judge. So if a trial judge finds that a certain fact took place, so a certain fact is true, courts of appeal don't like to interfere with that as a general rule. An example of a finding of fact pertaining to Johnny's case is that he was under the influence and violent during a particular episode or incident. The Court of Appeal goes on to say that they will interfere if a judge's finding of fact is unreasonable or unsustainable based on the evidence. And in their view, the claimant's case was one of those rare cases. And I believe, because of the parallels that exist between this case and Johnny's case, that Johnny's case also is one of those rare cases. So there were allegations of theft that have been made against the claimant. The judge bought these allegations, so he believed the defendants. He based his findings on the recollection of two witnesses that have been called upon by the defense. The trial judge said that he was prepared to accept this evidence, even though there was no love lost between the witnesses and the claimant. So the judge knew that the witnesses that were called upon by the defendants were hostile towards the claimant. They had an axe to grind. And of course, the same thing can be said about NGN's witnesses, specifically Amber, of course. The trial judge went on to say that he was unimpressed by the claimant's evidence and was impressed with the level of detail that was offered by the defendant's witnesses. The Court of Appeal found that there were a number of matters which seriously undermined the reliability of the defense's witnesses. Firstly, their statements were remarkably similar. They were not independent witnesses. In this instance, the two witnesses were in a relationship. But in Johnny's instance, an overwhelming majority of these witnesses, I suppose all of them really, were at some point incredibly close to Amber. They were not independent. They were her best friends, or in Whitney's case, her own sister. Secondly, the Court of Appeal pointed out, as I said earlier, that these witnesses had a serious axe to grind with the claimant. I've already talked about this in the sense that, again, directly applicable to Johnny's case and the defendants that were called upon by NGN. Amber, in particular, had a serious axe to grind with Johnny. But when you think about the fact that all of the witnesses were either Amber's family or really close friends, that argument can easily be applied to them as well. Essentially, they're very biased, and I don't know if they genuinely believed Amber's allegations. I'm talking about her friends, by the way, because they never witnessed anything. So I don't know whether they believed her, but there is no love lost between all of Amber's camp and Johnny. Now, this is not in relation to all of the witnesses that were called. I would say Melanie Iglesias, for example, didn't really have an axe to grind with Johnny. But in a general sense, that group was quite hostile towards Johnny. Thirdly, the Court of Appeal pointed out that these witnesses never reported any concerns or suspicions pertaining to the claimant and his business conduct during the last decade. So before they were called upon to testify against the claimant, these witnesses never reported anything against the claimant. So all of their allegations just came out of the blue for the purposes of this trial. Again, this can be directly applicable to Johnny's case because no one ever made allegations of abuse or reported anything about Johnny being an abusive person throughout his life. Then suddenly, out of the blue, these allegations pop up when the divorce became a reality. Everyone was just one big happy family until Johnny decided to end the marriage. Another thing the Court of Appeal did is they assigned credibility to the claimant's evidence. Now, the claimant didn't just rely on his own testimony. He called upon witnesses, independent witnesses, who actually worked either for or with him, who had first-hand knowledge of how the businesses were run, and also had first-hand knowledge of how the claimant was as a person and as a businessman. Specifically, the Court of Appeal said that the evidence of the witnesses provided by the claimant stood in stark contrast to that of the witnesses called by the defendants. Both of the claimant's witnesses worked at the relevant organizations and had direct knowledge of its operations, and neither had an axe to grind, unlike the defendant's witnesses. So unlike the trial judge, the Court of Appeal viewed the claimant's witnesses as independent and reliable witnesses that have provided credible testimony. A subcategory of this ground of appeal is the reversal of the burden of proof. The Court of Appeal starts off by reminding us that the burden of proof falls on the defendant to show that the allegations are substantially true, not the claimant. They remark that the judge was clearly aware of this, but at times it looked like he was suggesting that the claimant had to prove his innocence. For example, here they directly quote the trial judge. "A bunch of assertions is not going to cut any ice. I need proof. Strictly speaking, the burden of proof is on the defendant, but it's not going to work like that, in the sense that I will draw inferences." And this was not an isolated comment. So the trial judge at various points throughout the trial wanted the claimant to disprove the allegations that were being made against him. Now, the Court of Appeal wasn't entirely comfortable with definitively saying that the trial judge reversed the burden of proof, but his remarks seem to imply that that's what he did. So they agreed that there is a basis for the claimant's submission that this tainted the judge's approach to some of the evidence and could provide some explanation as to how he came to his unjustified finding that the allegations were substantially true. So the difference here between this case and Johnny's case is that Mr. Justice Nicol didn't exactly take this approach during the trial, at least not from what I read. In Mr. Justice Nicol's case, to me, his judgment read that way, in the sense that he believed NGN's side, primarily based on the testimony provided by Amber herself, and he did this without much basis other than the photographs that were provided, which some people can argue are compelling. Based on the contradicting evidence, I still believe that these photographs were staged. To take matters further, he decided to disbelieve, essentially, everything stated by Johnny and his witnesses, despite the fact that that too was testimony made under oath or affirmation. So it can be argued to be an effective reversal of the burden of proof, because what he's essentially saying is, unless you show me that this is not true, I'm going to take them for their word. Now, I am a proponent of assigning weight to the testimony of witnesses, because that's actually a major problem in the system that we have, and I've talked about this at length on my channel, with regards to crimes that are committed in private, which includes these sorts of domestic crimes or crimes of sexual assault as well. Sometimes a victim has nothing but their own testimony as proof. But that situation is vastly different to a situation where you have here an organization such as a newspaper, a publisher, or an editor, a person who makes false allegations against someone who they don't even know personally. They don't have firsthand knowledge of anything. When it's situations like these, you would expect that the defendants would have more evidence other than just their own word or their own beliefs. I don't think that having a bunch of very removed defendants, people who have nothing to do with the claimant, sit there on the stand and just say, we believe their allegations are true because we just believe that they are, or because these witnesses who despise the claimant say so. You would think that as a third party, because these journalists are effectively third parties, right? They're not involved directly in the affairs that they are writing about and publishing. You would think that they would have enough objectivity, enough impartiality to verify claims in a much more reliable manner, look for more evidence, reach out to the other side, some kind of substantive basis for relying on the defense of truth. Because that's the problem with Johnny's case. It's he said, she said, the judge decided to side with her. Except in Johnny's case, he actually had independent evidence and his witnesses had firsthand knowledge. They actually were there a lot of the times during the fights. They witnessed them. And let's not forget those recordings of Amber admitting to what she has done to Johnny and not for 1 second stating that he did the same to her. Her only complaint was, stop running away from me, stop splitting. That's independent evidence. That's a recording that was made. Yes, it was made out of court, but that doesn't mean you automatically assign 0 weight to it just because it wasn't made under oath. In fact, that was a spontaneous, contemporaneous recording, catching Amber speaking on the spot. That makes it more reliable than someone who is anticipating going to court and making up a story so that their allegations are believed. Perjury exists as a crime because people lie under oath all the time. So disregarding all of this independent evidence that Johnny had and favoring Amber's side simply because she said so can be read as a reversal of the burden of proof. Now, it's important to note that I'm not saying that these grounds of appeal are exactly Johnny's grounds of appeal. I don't know what his grounds of appeal are yet. So please don't mistake this as me telling you that these will be his grounds of appeal for sure, but they could be. We'll just have to wait and see. So the Court of Appeal found for the claimant. The appeal was granted, but they committed an error, which was that they didn't order a retrial. So the defendants ended up appealing that decision to the Supreme Court, and the Supreme Court, while disagreeing with the Court of Appeal's reasonings in some areas pertaining to public interest, eventually decided that there were enough grounds to justify a retrial. And the timeline is the original trial was, I believe, held in 2017. It was heard by the Court of Appeal in 2019. And then now, this year, the Supreme Court issued its final judgment pertaining to this case. I don't know exactly when the case is going to be set for a trial, but it will be interesting to see how it ends up once it's tried again. All right, that's it for this video. I do want to remind everyone that I'm not trying to give you false hope. I'm not saying that Johnny's appeal will automatically be successful purely based on this appeal, but it was imperative for me to share with you how things can go right, how even though you may have failed the first time at the trial stage, you still have hope and you can still appeal things successfully. It's also a good example of what I stated in my video when I analyzed the judgment. Judges can get it wrong. A judge is not infallible, and that's why the appeals process exists. As always, don't forget to let me know what you think in the comments below. Thank you so much for watching. Stay safe, and I'll catch you in a future video.